All right, hi, welcome back. Attorney Steve Vondran. Happy Friday. Today we're talking in this episode of Litigation Whiteboard about how you prove copyright infringements. Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, here we go, guys. Brought out the finger today, the famous finger. That's right. All right, so how do you prove infringement? So copyright infringement is a very simple, but yet has a lot of nuances and complexities to it. Proving copyright infringement. First two things. Two, you need to prove ownership, creation. You are the creator of these certain types of content here. Here we have a creative work of authorship fixed in a tangible medium of expression. That's the requirements to actually acquire copyrights. An original work of authorship fixed in a tangible medium of expression. This could be music, jewelry. We have jewelry cases where people are infringing on pendants and things like that. Characters, this is becoming big. Characters from books, movies, video games. You can protect those. Photos, videos, artwork. Fashion designs can be copyrighted. So if you have an original work of authorship fixed in a tangible medium of expression, it could be so many different things. Sculptures, all kinds of things, computer fonts, things like that. If you can show the ownership that you're the creator or you acquired it by a license or an assignment, you show that ownership so you have standing to bring the lawsuit. Now, if you want to bring a federal court lawsuit, you have to register your creative works. You have to register them with the Copyright Office. Not expensive, takes a little time to get it, but not expensive. You show you're the owner of the copyright and that somebody else copied, the defendant copied. Original expression, okay? Original expression. So how do you prove copying? This is basically, and again, down here, copying violates one of the bundle of rights, what I call the BOR. When you have a copyright registration, you're going to own the rights to make reproductions, make derivative works, different varying works to publicly display, and so forth and so on. So you have the bundle of rights. Copying, reproducing, distributing violates that right. So this is what we're talking about with the cause of action. So one, you show ownership. Two, ownership of a creative work of authorship fixed in tangible medium of expression. And then two, copying. There's two ways to show copying. One is you have direct evidence, okay? So maybe you have a photo and you see it on your site and it's on their site, the plaintiff, the defendant, they're both the same. You go, well, that's direct evidence. That's tangible evidence. You can see that with your own two eyes, okay? Right there, your own two eyes. So it could be an exact photo, it can be a t-shirt with your copyright design on it. It's obvious there's copying, right? That's direct evidence, the easiest way to prove it, but it's also not always most available, okay? Emails, you get email chains, you have a sequence of events. Hey, I like this logo, will you copy the logo? Yes, I'll copy the logo. Here's the logo, it's substantially similar. That's another way to prove copying, okay? Now, if you don't have the direct evidence, sometimes that's a little harder to get the direct evidence, you must look to circumstantial evidence. That's basically a two-part test. The plaintiff must show that the defendant had access to the copyrighted work and that it's substantially similar. Now, access can be proven by, you have proof of access. So in other words, you might have something where somebody's online going, oh my God, I love this artist. I love their works. They're so beautiful. Well, that tells you they have seen their work. And so that is evidence that you had access. That's important to establish circumstantial proof, okay? Also, if you can't show the proof of access, striking similarities will also get you there, okay? So either one. Striking similarities is you go, wow, you're using three of their things and three of their things and they all look so similar. That's strikingly similar. You must have had access. Don't tell me you didn't have it. You must have had access. So this is what you're looking for, either the direct evidence or the circumstantial evidence. So you need to show this access, and I just showed you two ways to do that. Proof of access, striking similarity, and that the copyrighted work was substantially similar to the infringing work. So you infringe the work, it's substantially similar, we know you had some type of access, that's the test for infringement, okay? So I know it's a lot of stuff up here, but showing substantial similarity, and many courts like the Ninth Circuit will break this down into two tests. for substantial similarity. One is a question of law. This is for the judge. The judge will look at the extrinsic test. They will allow experts to come in and say, well, wait a second, let's filter out the things that are not protected expression, things that, like a zigzag on a shirt. You can't copyright the zigzag. That's public domain. Everybody has the right to use a zigzag on a shirt, okay? So you will filter out through your experts things that are not original works of expression. That's the extrinsic test. And the judge could rule on a motion to dismiss right there. He could say, you know what, I'm not buying this, I'm not seeing it, and it go there. Now, if the judge says no, there's plenty of proof of substantial similarity. Now we're looking at question of fact. This is the ordinary reasonable observer test. This is what the jury decides. The case goes to trial. They will look at the work as a whole, the look and the feel, and get a feel for it, and decide if there is substantial similarity. If so, if you got all this, if you have copying, direct evidence, circumstantial, proof of X, the burden shifts to the defendant, final step. The burden shifts to the defendant to show a license or a viable affirmative defense, such as independent creation. I created this myself. It just so happens to be similar to yours, but oh well, it's a big world, right? We can both have the same concepts. Independent or fair use, another huge one. We do a lot of fair use opinion letters, and fair use, that you have a right to comment or criticize. You're using their photo in a movie or such. So there's a lot of different ways to go, but this is a general quick overview of how you prove copyright infringement. I hope this has been helpful. Of course, there's a lot of nuances. This is general legal information only and not legal advice. Feel free to share this video on your social media networks. And thank you for watching Litigation Whiteboard with Attorney Steve. If you need legal help, you know where to find us on the web at attorneysteve.com, the first name in legal services. Have a great weekend, everybody. Gotta run. Bye now. Make sure to subscribe.